I'm Christopher Hanson with Hanson Law Firm. Today I want to talk a little bit about how the commercial real estate markets are reacting to the COVID-19 crisis. Specifically, what's happening as of April 1st when tenants across the country are giving landlords notices that they are not going to be making the April rent payment. Now, for smaller spaces where it's, 1,000 square feet or 2,000 square feet, that may not be such a big deal. When it's 40,000 square feet or 400,000 square feet of space that's being rented, and those rental amounts are now not just a couple of $1,000s, but maybe $20,000 or $40,000 or $200,000 or $400,000, it's an entirely different situation. Tenants are wondering how they're going to make rent payments because their customers have been ordered to shelter in place. Landlords are wondering how they're going to make their mortgage payments because the tenants haven't paid rent. No one is expecting this. So what happens when you have an unexpected event? What are the obligations under a lease? The first thing you have to do is read the lease. And there's a provision in a lease called a force majeure clause. It's kind of what happens if there is an act of God that interrupts the tenant's ability to pay rent? Most people haven't paid any attention to the force majeure clause when it was drafted. Everybody is paying attention to them now. So when you read the force majeure clause and it has this list, as most of them do, it lists fire and flood and hurricane, tornado, lightning strike, those kinds of things, natural phenomena that are a superseding, intervening, no one expected it kind of event. And when one of those natural phenomena occur, the tenant is excused from paying rent on a property that it cannot use. Well, there are some jurisdictions that say that if you have listed a particular kind of event in a force majeure clause, and you have not listed others, that because it is about allocation of risk and assumption of risk, you've made an informed decision to protect yourself against certain things, and you've listed those things, but you haven't listed others, and therefore you have assumed the risk of the things you did not list. Most force majeure clauses do not include pandemics or epidemics or public health crises as one of the forces majeure that would excuse performance. Therefore, under a force majeure clause, a tenant is still responsible for payment of rent, unless it has listed a particular kind of thing. Now, I say in most jurisdictions, California is somewhat different than many other jurisdictions in many other ways. But one of the things that California has done is enacted a Civil Code Section 1511. And in Section 1511, California has said that if the tenant's performance is interrupted by operation of law, then the tenant is excused from paying rent. For instance, if the Second Amendment were all of a sudden taken out of the Constitution and California passed a law that said thou shalt not sell guns, every gun store in the state of California would, by operation of law, be out of business, and they would be forgiven for the obligation to pay rent. What's happened with a shelter-in-place order, however, isn't that the government has said thou shalt not be in business for dog groomers or hair salons or a hardware store or gymnasium, fitness center, right? And so their customers have been told to stay at home, but those businesses have not been shuttered. Some governmental orders have said, thou shalt close your business unless you are deemed an essential service. Okay, in that case, you have a governmental order that has suspended the tenant's legal authority or legal ability to continue to operate. That would constitute government action, I think. There's another portion of that Civil Code Section 1511, in case that government order is merely a suggestion and not a mandate, that says if there is some irresistible superhuman event, then it will act as a force majeure and prevent performance or allow an excuse for performance. Pandemics aren't superhuman. It's a human-caused occurrence. And I don't believe that in a strict interpretation of the way the statute is written and the way some case has interpreted that statute, that a pandemic will qualify as a intervening superhuman event. It may. We won't know for another 2 years until some court of appeal has made a ruling on it. So, what do you do today? First thing you need to do, read the lease. See what a force majeure constitutes in your particular case. Now, some force majeure clauses will also say fires, floods, hurricanes, or events, including but not limited to fires and floods and hurricanes or other perils. Well, including but not limited to, what does that mean? Typically, what it means is that if you have something that is akin to a hurricane, a fire, a flood, a lightning strike, if it is some kind of natural phenomenon, if those are the kinds of things you've described, if you say riots, war, shortages, then those are not natural occurrences, but civil disruptions. And so including but not limited would mean some other kind of civil disruption, or it would mean some other kind of natural phenomenon. If the lease says, or other perils, well, what's a peril? Insurance doctrine lists different kinds of perils, and so you may find yourself looking at your insurance policy to see if that helps you define what is a peril, that you might be able to use that definition in your lease. Most insurance companies do not list governmental action as a peril that is insured against. They list it as a non-insured or an exception to insurance. Natural phenomena are perils that are covered. So you won't know until, again, you pull out your policy and you read it. There's commercial general liability, there's business interruption, there are some umbrella policies that may apply. We just don't know until you read the policy. Now, one of the things that you need to do in a lease is give notice if you are going to try to use the force majeure clause. And you have to be really careful about how you give that notice. Because you may unintentionally give notice in such a way that it will act as an anticipatory repudiation of the lease. Hi, we are breaching the lease, we're not paying rent. Well, that means you've lost the lease completely, not just a forbearance of a month's rent or maybe two, but the whole thing. You have said, I am breaching the lease. Now, if you've got a really good under market lease and the landlord would like to find an excuse to get rid of you, you want to be really careful about how you use or what language you use in the notice that you give a landlord. There are other provisions that require you to give notice timely. So what was timely? Was timely when the government first issued a stay-in-place order in March? Or is it now April 1st? People will be arguing about that for weeks or months. There are other opportunities, for lack of a better word, if a force majeure clause in a lease does not allow for forbearance or forgiveness or delay in the payment of a rent. There are legal doctrines of impossibility and frustration of purpose. I'll talk about those in another video because this one is already going to be too long. But you want to make sure that you take a look at whether or not your performance is deemed legally impossible or legally frustrated as other opportunities to use as you begin the discussion with your tenants and landlords about what's going to happen with the April and likely May and perhaps even June rental payments. Now, one of the other things that you have to do is mitigate your losses, mitigate the landlord's losses if a tenant is not going to pay rent. And how do you go about doing that? Well, you can, if you're a bar, have takeout delivery for beverages. If you're a restaurant, you shift to delivery or pickup, but no tableside service. If you're a gym, you do online classes for workout classes, right? You try to keep your membership, your customers engaged and continuing to use your business. But you have to be careful when you're doing the mitigation, because with regard to those doctrines of frustration of purpose or impossibility, if it's not impossible for you to use the facility, you still have to pay rent, the full rent. And if it's not completely frustrated in the performance, or if the subject matter of the lease is not completely frustrated, right? You have an obligation to pay rent. And so just because you're not making as much money isn't an excuse to pay the full amount of the rent. There's no proration based on frustration or impossibility. So if you are mitigating your losses by having take-home food, you may be setting yourself for an obligation to pay the entire amount of the rent. If you're mitigating your losses by doing online classes, if you're a gym or a fitness center, you may be obligating yourself to pay the full amount of the rent, because the initial review of the case law that we've done indicates that it has to be a total frustration of purpose or totally impossible in order to use those doctrines, or even the force majeure doctrine. So, first thing you do is pick up the phone and call your landlord, call your tenant, have the discussion. If that does not work well, or if the discussion does not go well, you've got some additional choices. Do you litigate a claim? Do you try to arbitrate a claim? Again, you have to look at what your dispute resolution provisions are in the lease. There are some people who are saying that it is smarter to hurry up and file a declaratory relief action now, to get in line in the court system quickly, because the court systems are now just hugely impacted as well. Remember, all of those cases that were set up for April and May and June are now going to get booted, and there's going to be a ripple effect in all of those proceedings. If you're going to need speed and you need to do a declaratory relief action, it may be smarter to file now and hold your place. Now, arbitrations and mediations can often be done not in the judicial process, but in the extrajudicial process. There are private mediators and arbitrators. You may find that it is more practical, to try to use one of them now, and again get in line with an experienced real estate mediator or arbitrator to resolve the dispute. It's not going to go away, and the ripple effects on this are going to be felt for years and certainly months. If you need to get advice, don't wait. Find a lawyer. I don't care if it's us, I don't care if it's Joe McGee down the street, but get somebody that understands what the contractual nuances are and the insurance nuances are for your situation. And good luck. Oh, and wash your hands.